Hello everyone. Today is Thursday, April 16th. It's good to be able to speak to everybody again. We've been doing these weekly remote conferences to educate you on some of the changes in the law and also try to help you become less anxious, if you would, about your estate planning needs. I once again want to thank all of the nurses, doctors, first responders, everybody that's out there trying to help people that are in need. We greatly appreciate and respect everything that you've been doing for us. Over the last couple of weeks, if you've been participating in these conferences, we've been talking about the changes in the laws and how Governor Cuomo has signed certain executive orders, making it easier for us to help you fulfill your estate planning needs, which is plantodayfortomorrow.com, and you can review those videos if you wish. I'm not going to spend much time today talking about those procedures. We're starting to implement them, and we're signing more and more plans now remotely. So we're in the comfort of our own home, you're in the comfort of your home, and following certain procedures, we can attend to the signing of a will, a trust, a power of attorney, all these documents that we would normally be drafting and signing in the office. What I'd like to do today is talk a little bit more specifically about the planning techniques that you might want to consider. And there's a lot of different planning ideas and opportunities that we implement on a regular basis. And we're going to continue doing these on a weekly basis. So we're just going to talk today about trust. Now this is somewhat complicated. What I intend to do here is give you a flavor for what the planning techniques look like, what the drafting might look like, but in no way can I really educate you fully as to the ins and outs of a trust in a short period like this. If you get a sense that what we're talking about today might be something that you should further explore, that's when I want you to call me or email me. We can respond very easily by email. I can answer all of your questions. Any questions can be answered. If I were to fully educate you on a revocable trust or irrevocable trust, I would need a lot more time, and it gets much more technical. So today I want to talk about revocable trust, because in the climate that we're in, trusts are becoming way more important than they have ever been before. Trusts have always been popular, and trusts are a really useful mechanism to do a lot of different things. There are two types of trusts, generally speaking, that we use: revocable and irrevocable. Let's talk about revocable first. What is a revocable trust? It's really nothing more than a piece of paper. People hear the word trust and they say to me often, "But Sal, I don't have a lot of money, or my estate is not that great. Why do I need a trust? I'm not one of these rich people that you see on TV." Well, that's the wrong way to look at it. A trust is useful in many scenarios, and it's not necessarily tied into how much money you have. A revocable trust is a piece of paper that really says the same thing as a last will and testament. So for instance, my trust might say, when I die, give my assets to my children, or give my assets to my wife, or leave this particular asset to that person, or set up another trust for another beneficiary. My will might say the same thing. So it's not really different. The difference between a revocable trust and a last will and testament is that a revocable trust avoids probate. Now, probate is the process of taking your last will and testament when you die through the legal system, through the courts. That process could be cumbersome, it could be costly, it invites people to fight, and often people try to avoid the probate process. One of the things that we're seeing now is that the courts are closed. And we're expecting that when the courts open up for business again with non-essential matters, which the filing of a probate would be a non-essential matter, we think that the courts are going to be backlogged, overwhelmed, and the time period that it takes to probate a will is going to be far greater than it ever has been before. Now, I could be wrong, and we have an excellent staff in the surrogates courts in New York State, so this is not anything against their ability to get it done. It's just that a lot of stuff has been on hold for the last month and will continue to be on hold for quite some time, so we don't know how long it's going to take. To avoid probate might be a really big deal going forward. When do you absolutely want to avoid probate? There are certain instances or certain fact patterns that really require you to think long and hard about drafting a revocable trust and avoiding probate. If you have property outside of New York State, so for instance, I received a call from somebody the other day that's got property in Florida. When you die with a will, we have to probate your will in New York, and then we have to go to Florida and do it again. It's called an ancillary probate. So when you own property outside of New York State, you really want to think about setting up a revocable trust, because by doing so, you can move your out-of-state property and your New York State property into that trust and avoid probate in New York and Florida upon your death. Maybe you have disabled beneficiaries and you need to set up a special needs trust. Whenever we're talking about setting trust up for beneficiaries, it could be a disabled person, it could be a minor child, it could be any child for that matter. We really want to avoid the courts in the process of creating and administering trust. If you do it through a revocable trust, and we can avoid the court process, the administration of those trusts for the future and the ongoing administration of those trusts will be easier for the trustees and the beneficiaries. So that's another great reason why you might want to avoid probate. Perhaps you have distant relatives. Often we get consulted by people that are single, maybe they were never married, and they don't even know who some of their cousins and perhaps nieces and nephews are. We don't want to have to probate a will in that scenario, because the probate of a will requires us to get those people to sign documents. And again, a revocable trust can avoid all of that. We're using revocable trust often for younger families who want to put their affairs in order, especially in light of this pandemic. To leave assets to a minor child, it's not prudent to do so without leaving those assets to that child in trust. And so because we're talking about further trust for the benefit of your children, we should do that through a revocable trust to avoid probate. So if you're a younger family and you want to put your affairs in order the right way, a revocable trust should be considered for your children. And there are a lot of different options on how we can leave assets to children, and I might do another piece just on that. One of the things that a revocable trust does not do, it does not protect your assets. So for instance, let's say you need care in the future. Let's say you need home care or you need nursing home care. A revocable trust is still considered to be your asset. So the assets inside of that revocable trust are still available if you get sick someday. After you sign a revocable trust, in order for that trust to work properly, we have to put your assets into the trust. You've been hearing me say the assets are inside the trust, but I skipped over how that happens. Once we sign your revocable trust, if you own a house, we'll take the deed to your house and redraft it so that way you now own it as trustee of your revocable trust. By the way, you are the trustee of your revocable trust. You could appoint other people, you can appoint co-trustees, but you are the trustee of your revocable trust. You can take those assets out, you can do whatever you want with those assets, it's completely yours. But your assets have to be in the trust. So the house goes in the trust, your bank accounts go in the trust. Your assets that have beneficiary designations, like an IRA, a life insurance policy, those do not go in the trust. You just make sure that your beneficiary designation is properly drafted. That passes outside of the trust. We don't need to put that into the trust. So we've got to look at your assets one by one and make sure that we're accounting for all of your assets. And when all is said and done, you'll have a revocable trust that's funded with the proper assets. And when you pass, we don't need to probate your estate. If you lose your capacity prior to death, if you lose your capacity, you can have a successor trustee in your trust that can just step into your shoes and manage your assets. So that's another great reason to consider a revocable trust. Because a revocable trust does not protect your assets, we have to look towards another type of trust to protect your assets. That's what we often refer to as the Medicaid trust. It's an irrevocable trust. And that trust is what we use on a regular basis to protect your house, maybe your brokerage account assets, other types of assets. Because we're trying to plan for long-term care someday. So if you're somebody that's in your 60s, let's say, and you're starting to think, listen, I know there are these rules from a Medicaid perspective that go back 5 years, and I really want to try to make sure that my house isn't taken if I get sick, and perhaps my kids have an asset that I could pass on to them. We really have to start talking about an irrevocable trust. I call that a Medicaid trust because I don't want you to get confused. I've got such a nice Italian accent that sometimes it's hard for people to discern between revocable and irrevocable when I say it. So I say revocable Medicaid trust. You really can't confuse the two when you're speaking with me. And the reason why we talk about a Medicaid trust is because you've got to figure out a way to pay for your long-term care someday. And there's very few ways to pay for your long-term care. You could pay for it yourself, which is very expensive. Most nursing homes are about $15,000 a month. You could have long-term care insurance, which in today's day and age, a lot of people don't have. Maybe it's too expensive. Maybe you don't qualify for it. It's something that should be looked into, but a lot of people don't have it. Medicare is an option to pay for your long-term care, but Medicare only pays for, at best, the first 100 days in a nursing home. So you're really left with Medicaid as being the fourth option. And we do a lot of Medicaid planning. We do a lot of planning for all types of generations. We set up revocable trust for a lot of the younger generations that are looking to leave assets to their kids. We do just regular wills and regular estate plans for anybody in between. And then for the more seasoned generations, we start working with these Medicaid trusts to try to protect your assets. And an elder law attorney, in the law firm of an elder law attorney, that's bread and butter. That's what we're working on a regular basis. The revocable trust, as I mentioned a little bit before, has a 5-year look-back period. And often, people will put their house into the Medicaid trust and maybe no other assets. And once that 5-year period is gone, or has elapsed, that house is protected. If you get sick, Medicaid can't look at it. They can't put a lien against it. While the trust is in existence, you're still responsible for paying the taxes. You've got the right to live there. Nobody can kick you out. You'll usually appoint your kids as the trustees of that trust. They could sell the house that's in the trust, but they can't sell it without your consent. And there are a lot of other bells and whistles that we draft in these trusts that make it as flexible as we could make it, but without crossing the line. And that line is that you don't have the ability to necessarily take those assets back or benefit from those assets. So for instance, if we put a $500,000 brokerage account into a Medicaid trust, you can't just go in there and write yourself out a check. You can't just go in there and use that money. The trust does entitle you to the income on that $500,000, but you can't use that money as if it's in your checking account. And that's precisely why it's protected if you get sick someday, because we've cut it off. We've taken certain assets that you really don't need. The house, as long as you can live there, as long as you can put the key in the door and go to your bedroom at nighttime and go to sleep, that's great. Monies, we won't put the money in the trust unless we know that you don't need it. So we'll never try to protect your entire estate. We'll never put all of your assets into a Medicaid trust. We'll put a portion of your assets into the Medicaid trust. And by doing so, you're saving a reasonable amount of assets. Yes, we're still leaving assets out there exposed, but that's not a bad deal. That's not a bad handshake. And of course, upon your death, the trust terminates and the assets pass to your children or to whoever, and we can do a lot of different things when those assets pass to your heirs. We could set up further trust. We don't have to. It could be outright. But at least we've protected the assets. It's really sad when we have people that come in here. Usually it's the children. And the children might come in and they'll be sitting in front of me at my desk and they'll say, Mom and Dad, Mom's in the nursing home, but she did all of her planning already. I said, okay, tell me about Mom's planning. Well, she went to an attorney, by the way, all attorneys are not the same type of attorney. So you'll hear me preaching often about how you must hire an elder law attorney to do these types of things. Please don't hire just any local general practitioner attorney. They may be great people, they may do awesome real estate closings, but this particular area of practice is unique, and you should be working with an elder law attorney. But going back to my example, it's sad when the kids are sitting in front of me and they present me with the documents that Mom drafted, and often it's a revocable trust. And if Mom drafted a revocable trust, those assets are not protected. There's no 5-year look-back period. It's revocable. And that happens often. People go to these seminars, they go to these lectures, they draft these trusts, and they think that they've done their planning, but they haven't done any asset protection. So we want to be careful about that, and that's why I take this time to educate you so that way you're not making the same mistake. That's a really big mistake that we see on a regular basis. But if it's done right, the kids are really in a good place, and the estate is protected. Now, I mentioned in my last week's video that they just recently changed the Medicaid laws, and they did. There never used to be a look-back period, or at least in my practice, in the time that I've been practicing, on home care. So if somebody needs home care, we were able to take the assets of that person, move the assets to anybody that we wanted to, it didn't matter, and apply for Medicaid to cover aides in the house the next month. Now, recently, the law changed, and there's a 2.5-year look-back period now for home care purposes. This is really important, and I hope people listen to me when I say this. Effective October 1st, there will be a 2.5-year look-back period. We're not sure, the way the laws were written, we think that they can go from October 1st backwards in time to now. We're not sure anybody's going to be grandfathered in. In other words, whatever you do now might still be captured in that 2.5-year period. We're not sure. We're hoping that something comes out that gives us a little bit more guidance and hopefully says after October 1st, the 2.5-year look-back period is in effect. But right now, the way things have been written, we don't think that, we're not sure if that's going to happen. So they're going to be able to look backwards 2.5 years. So a lot of people would come in and they would say, oh, I don't have to do a trust. I'm never going into a nursing home, which that's a terrible way to think about your long-term care. And there are a lot of different ways. If anybody listening is in the medical industry, there's a lot of different ways somebody can end up in a nursing home unexpectedly. But a lot of people would say, I don't need to do the trust because I'm never going into a nursing home. And you know what? My daughter promised me that she's going to keep me at home as long as possible. And if we need to, we'll apply for Medicaid. I know that the rules are very relaxed. That's not the case anymore. You can't sit at home and expect that when you need care, we're going to be able to apply for Medicaid because of this 2.5-year look-back period. Now, it's not a 5-year look-back period, but it's a 2.5-year look-back period. So if anybody is on this video right now that's listening on behalf of their parents, that's usually the challenge, because sometimes our parents, they don't want to take our advice. So I need the younger generations to not only call me for your own estate planning, but to really try to get in front of your parents and say, hey, mom, dad, you really need to do something. And that something is the Medicaid trust. That Medicaid trust that I just described to you is becoming even more powerful. It's becoming even more prudent, because not only are we doing it for nursing home protection, but now we have to do it for home care purposes. We have to plan for the possible need for home care, and this Medicaid trust is the way to do it. So you're going to start hearing more about it, you're going to start seeing more of it, and a lot of your friends are going to have it. We lecture about it. It's a really useful technique to implement in advance. So with all of that being said, I wanted to give you a flavor for trust. We have revocable trust, we've got the Medicaid trust. There's other types of trust that I'm not talking about. There's all different kinds of tax planning trust. And then there's trust for disabled people, there's trust for your children. But ultimately, a trust is a really useful mechanism for protecting assets, making sure that minors or spendthrift children don't have access to a lot of money, that they're not going to be wasteful, they avoid probate. So we should really be thinking about trust as part of your plan. With that being said, if there are any questions, please feel free to email me at smd@mfd-law.com. I'll answer all of your questions as timely as I possibly can. You can call 914-925-1010. That's the Rye office. You can call me in Yorktown at 914-245-2440. And my website is Plan Today for Tomorrow, all spelled out, one big gigantic word. And you can go onto my website and get more information about a lot of the things that we do on a regular basis. Other than that, I wish everybody safety and wellness, and I look forward to seeing you again. Thank you.